Now, what does it mean when we talk about costs in international arbitration? What are those costs? What is the money that you will be spending on your arbitration? And here I'm going to simplify a bit the things, just to make it clearer and help you understand better the issues at stake. You can actually separate costs in arbitration in two parts. On one side, you have all the costs relating to the proceedings. And on the other side, you have the costs relating to party representation and your actual participation in the proceedings. So looking first at the costs of the proceedings. Here again, you can divide it into subgroups. And the typical subgroups you will find regarding the proceedings as such are first the administrative costs of the arbitration institution involved. The arbitration institution will usually levy a registration fee and very often also a handling fee. The amount of those can vary from institution to institution, and here also there is a high competitive environment among international institutions worldwide. So that's the first subgroup of the cost of the proceedings. It's the administrative costs of the arbitration institution involved. The second subgroup is, of course, the arbitral tribunal. They'll decide on the dispute, and so you also have to pay them. They're not doing that for free. So as a second subgroup, you have the arbitrator's fees and the arbitrator's expenses. And as a third subgroup, and here one could, argue whether it's the right place to put it, but I like to put it here because those are costs that are really related to the proceedings themselves, and I call them incidental costs. And you have typically additional costs of an administrative secretary if anyone is engaged, and the arbitrators suggest and the party agree that this administrative secretary is paid separately. It's the exception. Usually administrative secretaries will be included in the arbitrator's fee, so they will not be charged separately, but it's arbitration, party autonomy. And I did attend a few arbitration proceedings where the fees of the administrative secretary were paid separately. Other incidental costs that will occur very often in practice and can be quite substantial actually are translation costs. So translation of documents, of course, but also interpreters at the hearings where you have witnesses or parties that need to have assistance of an interpreter, and also court reporters at the various hearings to take a transcript of the hearing. So these are the costs of the proceedings with these three subgroups. And on the other side, we have the second group, which is the costs relating to the parties' representation and participation. And here again, there is no really, one way to present those costs. And I'm just trying to present it the way I've experienced it and the way I think will be quite telling and quite easy for you to understand. In the middle, and by far the biggest cost, we'll get back to that, are the lawyers' fees and expenses. Lawyers still today, in most parts of the world, bill by the hour, okay? So if you have, the longer your arbitration goes, the higher your lawyers' fees and expenses. But around those lawyers' fees and expenses, there are a lot of other fees and expenses that can get quite substantial too. First, cost of witnesses. Usually witnesses are not paid. They're not supposed to be paid. Fact witnesses, okay? But you might have cost of traveling, which can be quite substantial depending on the length of the hearing. But there might be some costs involved with witnesses. More importantly are the cost of expert witnesses, because those are normally, or they should be, independent experts. It can be technical expert, typically, for example, a construction engineer that has to give an opinion about the existence of a defect. It can be an accounting expert that has to review the books of a company or a certain transaction. It can be also legal experts. So those are all professional experts that will render their report against a fee. And that fee can be also quite substantial. So here we have also each time fees and expenses. Another item is becoming more and more important and more popular to be claimed in arbitrations are the costs of the in-house management. Indeed, imagine you are a company involved in a dispute, a big dispute, it's an important dispute for your business, and you want to monitor it closely. And it's about a project that lasted for several years, maybe it's already some years ago, and you have to dig out a lot of information. So it will take quite some time of an in-house legal department, if there is one, but very often also of the management themselves or of the project managers that are asked questions about the facts, and they have to go back into their file, into their email, dig for information, figuring out again what happened, what did I say to whom, when. And this can take quite a lot of time. And companies have increasingly started to try requesting reimbursement of those costs in arbitration because they think, listen, I haven't been able to use my project manager on the project because he's been so busy working on that arbitration, and I've still been paying him a salary, and all this money was for nothing. So they are claiming actually reimbursement of those costs. This item is quite controversial. There are two views to it. One view is to say, disputes are part of business. It's like a project, it's a dispute. You do business, you get into disputes, so that your team is sometimes involved in dispute management. That's normal, that's part of your business. You should not get separate compensation for that. And then there's the other side that says, yes, but come on, it's depending on how much time you spend, how complex the dispute is, the amount of time and effort that requires might be excessive to expect or to include that in the usual business risks. Another item are also potential costs relating to parallel court proceedings. You may have chosen arbitration, but you may still need urgent interim measures. And so one of the parties will go before a court and request interim measures from a court. It can be also cost relating, for example, if you were in an ad hoc arbitration proceeding with the appointment of an arbitrator before the appointing authority. If one of the parties doesn't participate in the appointing process and you need to go before the appointing authority to appoint your arbitrator, there will be cost involved. It can be also a decision on the challenge of an arbitrator. So there are certain court proceedings that can happen in parallel to an arbitration, which will obviously trigger also costs. And the last item I like to mention, but I don't really know yet how important this item is going to be in practice, it's legal tech. Legal tech, it's becoming very popular. In-house departments are investing in legal tech. Lawyers are investing in legal tech. It can be for example, document research, so a discovery research software. It can be automated translation softwares. It can be a automated case law research software. Who is going to pay for that? Is that going to be included in the lawyer's fees and expenses? Will clients be supposed to pay for that separately to buy the software? All these are open questions, but keep that in mind because that is a topic that will become more and more relevant with time. So these are a bit all the costs that you can encounter on the side of the parties' representation and participation.